Daquantez Moore. Mr. Moore, could you unmute and state your name for the record, please?
Oh, there it is.
Daquantez Moore.
Thank you. All right, what are we doing?
Your Honor, we are asking for an adjournment in this matter. We're still working on an agreement with the prosecutor. We'd also like to address bond.
He's out. All right. Probable cause conference, November 2nd, 2023, 9 a.m. Oh boy, this could go south. Go ahead. What about bond?
Your Honor, Mr. Moore is currently on a home confinement tether. I was not the attorney who worked on this matter previously, but my understanding is that one of the reasons for the home confinement is because the court was under the impression that his tether from, I think it's Macomb County, was also a home confinement tether. We have since received the information confirming that it's a GPS tether. We're asking that the court, first, we're asking.
Hold on, but it's a GPS. I mean, a GPS can be a home confined.
Yes, I think it's only for purposes of keeping track of his whereabouts. It's not just simply.
So it's a location tracking.
Thank you, Judge. I'm gonna write that down so I can say that next time. It's a location tracking tether. So we're actually asking, and I know that we've spoken with the prosecutor about this. They're going to object to that particular request. He still has the GPS tether, the location tracking tether from Macomb on, and he also has the one from Washtenaw County on.
So let me just tell you, I remember hearing this the last time.
Okay.
And what's very clear from the order was that the magistrate ordered a home confinement to an address and then said currently has a tether from Macomb County and is confined to home.
I understand that, Your Honor. And I think that we have received confirmation on what the details of that tether was. Mr. Moore, am I correct? Is it a home confinement tether from Macomb?
The Macomb County is just a GPS tracking tether to make sure that I don't leave the state.
If I could be of assistance, Judge, Torshell Feaster, Assistant Public Defender.
Get out of here. We don't need your help. Get out of here, sir.
I did have the case last time, Judge. I'm always willing
get
to
out,
help.
and he's still talking. Apparently doesn't listen either. Go ahead.
I'm a bad listener sometimes. I just want to confirm that I did receive an email from his agent, from his tether agent in Macomb County, and I believe we forwarded that to the prosecutor's office as well. So we do have confirmation that it's just a location tracking tether that he has there, Judge. Just want to be helpful. So, sorry, I'll go away.
No, I'm just trying to figure out how your office mate didn't tell me all that.
Well, you know, she's new to the file, Judge. She's got a new assignment.
Oh, okay. No, I don't know. Miss Hughes, your response.
Thank you. Thank you for also clarifying what the notes in the file were. I am not in agreement to him being on only a GPS tether for a couple of reasons. One is, first I'll say, I was not present at this arraignment, so I don't know for certain. I understand what Your Honor read into the record from the magistrate's notes. I don't know for certain that the only reason that Magistrate Fink, or whoever the magistrate was, issued a home confinement tether was because he or she believed that he was already home confined from Macomb County. Instead, at the time of arraignment, my office requested a $20,000 cash surety on this case. I am continuing to request the home confinement tether, or frankly, I mean, he can wait in jail if he doesn't want to be on a home confinement tether. This defendant, so this is a home invasion case. The defendant and his co-defendant or co-suspect are on surveillance video. They entered a home that is actually not too far from the address that he is currently home confined to. It's about a 6-minute drive. He entered the garage of that home, and the garage door had been inadvertently left open overnight, and the defendant and his friend went in and stole things from the garage. He does have quite a criminal history, though, in the sense that he was on parole and discharged from parole on November 30th, 2022 for receiving concealing a motor vehicle. This was even after he was already on felony probation for unlawful driving away of a motor vehicle, as well as multiple assaulting the police R&O convictions. He has an extensive juvenile history that includes home invasion, UDA, CSC, indecent exposure, aggravated assault, another UDA, another receiving and concealing motor vehicle, more R&Os against the police. So my understanding, and this is just limited to my review of the file, I was not present at the arraignment. My understanding was that, I should say it like this, my belief was that a home confinement tether was ordered because that is appropriate supervision for this defendant who has continued to commit these crimes despite already going to prison, despite already being on felony probation, and despite already being on parole. This is an appropriate supervision for him at this time, even if Macomb County decides to only give against Heather. Thank you.
All right. I would agree with that. I looking at defendant's previous history and the proximity of these offenses to parole and his release from parole, the court is going to decline to change the GPS tether. That will remain in place. Bond will continue. Thank you.
Thank you.
Thank you, Your Honor.
Court does call the cases of the people versus. Court calls the case of the people versus Cameron Curtis.
We are pleasingly ready in this matter, Your Honor.
Alexander on behalf of the people.
Anna Lauren Brown, Deputy Chief Public Defender, appearing with and on behalf of Mr. Cameron Curtis. Mr. Curtis, please state your name for the record.
Cameron Gage Curtis.
Your Honor, today is the date and time set for probable cause conference. We are respectfully requesting to have this matter set for preliminary examination, and we would like to address bond briefly.
All right, all discovery is complete.
As far as we know, yes, we have all the discovery.
Preliminary examination will be set October 24th, 2023, 9 a.m. I'm sorry, before Judge Washington. As to bond.
Your Honor, my client is respectfully requesting that his bond be reduced to $5,010%. He does have a job in Belleville, Michigan at the Red Oak. He is employed as maintenance. He lives in Belleville. He will follow all strictures and requirements of the court. He will appear to all future court dates. He has no place to which he would flee.
Response.
Your Honor, at this time, we believe the bond is appropriate and ask that it be kept the same. In this, the victim and him had been dating on and off for 7 years. She stated that he assaulted her multiple times over the previous 3 days, and the first assault occurred when he got angry at her and she was trying to calm him down. He then strangled her by grabbing the front of her throat with his hands. She tried to get away from him. He then grabbed her hair and attempted to force her into a room. She was then able to get away and fell into the concrete as she was trying to escape. She then got into her mother's car, who just arrived, and he came up to her in the car and slapped her in the face. Officers saw injuries to her neck, face, and arms when they arrived. He also has a 2021 DV conviction, another 2021 DV conviction, and then a 2021 malicious destruction of a building misdemeanor conviction. So we believe bond is appropriate at this time.
Your Honor, my client, of course, denies the allegations in this matter. He feels that he will be vindicated at preliminary examination.
Motion for bond reduction is denied. Bond will continue.
Thank you.
Thank you.
Your Honor.
Pardon?
2 weeks, please, Judge.
All right, here's going to be the problem with this, and there's going to be another case along these lines. This bond was improperly set.
Oh, okay.
The arrearage on this matter was at the time was $333, and his bond in this case should have been set. I mean, even if I just take it from the 18, his bond should have been about $4,500 plus, but and he was released on a PR, which is absolutely inappropriate in violation of statute. So we're going to have. Well, I don't know what you wanted to say, Mr. Goebel.
The Ms. Fink, the judge said that unless there's probable cause of why I didn't pay, then that's the only reason she can give me the PR.
Excuse me?
She gave me the PR bond because she said that it says under the statute that if there's probable cause of why I didn't pay, if she feels like there's probable cause, then she can give me a PR. And that's what she did.
I don't think that's the reading of the statute, but there would have to be a finding of that. And I'm not sure that the Attorney General was there to give probable cause.
Okay.
Your bond was set in that amount. The court does find that that's an abuse of discretion in setting the bond in that amount.
How much is the 25% judge that he was supposed to have paid?
The 20, based upon what's on the complaint, and it may have gone up now. To get the exact figure, I can give it to you just a second. I think it's 18. It'd be $4,583.
Okay.
So what I'm going to do, sir, and I apologize to you, but that the statute is what the statute is. And it requires that it be set at 500 or 25% of the arrearage, whichever is greater. And obviously the arrearage is greater. So your bond will be set in the amount of the $4,583. There's 25 cents, but I'm not going to worry about that. I'm just because $4,583, that has to be paid in cash, and that needs to be then applied to case number 2006-000-159DP.
Your Honor, I do not have that money to pay that.
Mr.
I understand, sir. I may understand that. And that might have to be dealt with otherwise, but like I said, I don't write the statutes. I just have to enforce the statutes that's written, unless some other agreement can come up before council that they think the court would approve. But at this juncture, I'm going to set your bond at that amount. Regrettably, sir, I'm going to have to order that you turn yourself into the Washtenaw County Jail, and that you're to report to the jail by 6 p.m. this evening, or a bench warrant will issue with the bond set in that amount.
Mr. Goebel, I just put my phone number for the office into the chat. Please give us a call so we have your updated information, and we can talk about the bond and potential ways to remedy the situation for you.
All right.
Okay, so call us immediately, please.
All right, I need
And I will, despite of that regarding the bond, I will adjourn the probable cause hearing. I'll adjourn it to June 8th. My apologies, but I have to do my job.
Your Honor,
Thank you.